Okay, excellent. I think we're live now on Facebook, LinkedIn, YouTube, TikTok, and Instagram. You guys are welcome to this live session. We have a lot of things on the table to discuss. Please make sure that you can hear me and see me. If you can hear me, please just share or type in the comment box USA, or just put the USA flag, or just type USA. Let me be sure that all platforms can hear me and see me well, and then we can get started. We have about 4 topics to discuss, and we'll be answering questions. So get your questions ready. Make sure you guys let me know if you can hear me fine. Please drop USA. All those who can hear me, please drop USA. Okay, I see USA from TikTok. I don't see from Instagram yet. I don't see at all on Facebook, YouTube, LinkedIn. If you're on those platforms, please drop USA if you can hear me well. All right, guys. Let's get started. So we're going back to birthright citizenship. There have been a lot of questions and confusion and chaos in the United States. I was thinking about this yesterday, and it's, the Supreme Court of the United States, they are very, very interesting, very, very interesting people. Because, well, we understand that that was not what was presented to them, so they couldn't decide on the constitutionality of the executive order. But it's very interesting. Let's say somebody takes, maybe reports to a teacher, or let's say a teacher or the Supreme Court, that, well, this teacher has banned us from eating bread. The teacher, so students go to the Supreme Court, to justice, go up to the justices and report that this teacher has banned us from eating bread, for example. In this case, it was obviously Trump administration that took the matter to the Supreme Court. But let's take that for example. And then the Supreme Court judges will say, well, we're not going to decide on whether it was constitutional or not to ban eating bread, but we're going to decide on whether the teacher could ban it for the entire country. You cannot ban it for the entire country, but will not decide the main matter. Well, that wasn't brought before us, but it's caused a lot more chaos and confusion, because now many people are uncertain with what's happening. So we're going to go back again, and then I prepared some frequently asked questions that we can take a look at. But as you guys know, January 20th, 2025, Trump came out with an executive order and said, birthright citizenship, he's going to limit it or restrict it. Now, if you give birth in the United States on U.S. soil, your baby will not automatically get U.S. citizenship if one of the parents is not a U.S. citizen or a green card holder or a lawful permanent resident. And if one parent is undocumented, one parent has temporary status, then the baby will not get U.S. citizenship unless another parent has either U.S. citizenship or lawful permanent residence. And so the deciding factor is that one parent at least has to have permanent status, either U.S. citizenship or lawful permanent resident status. And this was the whole matter. Several states and advocacy groups took the matter up to district courts, saying it was unconstitutional. And these district courts gave nationwide injunctions and said the order that was supposed to take effect 30 days from when it was signed, February 19th, to ban, meaning that all babies who were born in the US from February 19th, you could not obtain US citizenship unless one parent was a lawful permanent resident or a US citizen. The judges, district or federal judges, blocked the executive order from taking effect, and Trump and his cohorts were not happy. They appealed to the Court of Appeals. Court of Appeals did not agree with them. They took it up to the Supreme Court for an emergency stay of the injunctions, the nationwide injunctions, and brought a procedural matter and said, you cannot, when Trump just was not happy with that, because he had been complaining that why would a judge, a president give an order and district judges are overriding or overruling that order by nationwide injunctions. And they were not happy that many of their executive orders were being blocked by these nationwide injunctions. So they're like, no, there has to be something more. This is a problem. The Supreme Court obviously didn't decide on the contents of the substance of the executive order, but just said, oh, procedurally, if you are looking to ban or block an executive order like that, you cannot sidestep, I believe, rules of procedure 23. There is a process for doing that. If you want to do that, you got to make sure that you have a properly conducted class action. So there's a procedure according to the Federal Rules of Civil Procedure 23A. One or more members of a class may sue or be sued as a representative as representative parties on behalf of all members, so long as you are able to satisfy Rule 23 requirements. But what they were doing, the advocacy groups and the plaintiffs and the states that sued, they were looking for a shortcut. So they forged a shortcut to relief by seeking universal injunctions and circumventing Rule 23 procedure protections that said, create a class action before, relief can be given to all those people. So Justice Barrett asked a rhetorical question in the judgment. She said, why bother with the Rule 23 class action when the quick fix of a universal injunction is on the table? So Justice Kavanaugh also agreed with that and also said that, well, if they proceeded under a class action, then there could be statewide, region-wide, or even nationwide blocking. But as it stands now, only the named plaintiffs or the people that brought the suit could benefit from the injunction. And apparently it was 22 states that sued plus Washington, D.C. And according to Justice Sotomayor, the county and the city of San Francisco as well. I see that missing from a lot of the reports, but obviously this issue is very, it's gotten very chaotic. So it's not very easy to break it down. So yeah, those 22 states, DC, and then the city and county of San Francisco sued. And so they are the people plus the named pregnant women who were in the suit who can benefit from the injunction. Everybody else, the executive order will apply. They are going to be restricted from their children getting birthright citizenship so long as one parent is not a US citizen or a lawful permanent resident. And so the plaintiffs in the suit, Trump versus CASA, that's the Trump against CASA. CASA is the advocacy rights group. They immediately filed an amended complaint that same day. Was it Friday? Yes, last week, Friday. And a motion for class certification within hours of the Supreme Court decision. I believe other plaintiffs also did the same. And so we are waiting to see what will happen. There are some hearings going to happen within this month, the early part of this month. But the executive, the Supreme Court judgment said that the Trump administration has a 30-day ramp-up period to develop and issue guidance about how the executive branch or the Trump administration will implement the executive order. I hope everybody can see me and hear me good. All right. Okay, so that 30-day ramp-up period, I have a feeling that this is likely going to be blocked, but we have to wait and see. We certainly have to wait and see. It could end up back at the Supreme Court to decide on the constitutionality of the matter. But in the meantime, nothing, the status quo remains. Every child born on US soil is still a US citizen, unless, of course, they are not subject to the jurisdiction of the US, like diplomats or, foreign diplomats or enemies to the United States. So those types of people. But otherwise, everybody else, whether you are documented or not, so long as you give birth on US soil, then your baby is a US citizen. We are waiting to see by July 27th, or perhaps before then, whether the class actions will be effective and, what the outcome will be. and the Trump administration, they are very serious. The advocacy groups and plaintiffs are also very serious. So it's really a legal battle going on, and nobody's ready to back down. So let's look at this. Let's see here. Let's look at the states that sued. So let me see. Well, 22 of them. Well, I don't know if we should necessarily go over all these states. Well, we'll post it on our social medias anyway. I'm sure by now many people already have the list, so that's fine. All right, so the first frequently asked question, or one of the questions we've got, is how did this issue start and what has changed? We answered that currently even undocumented immigrants who give birth in the US, the babies get US citizenship. Trump executive order said no. Now only if one parent is a US citizen or a lawful permanent resident will the child get US citizenship. Executive order was supposed to take effect February 19th. States and pregnant women sued. Nationwide injunction, it was blocked from taking effect. Question number 2, so what happened? So the states plus DC, pregnant women, they have been granted injunctions blocking this nationwide. Obviously, we are waiting to see how the class actions that have been filed, or the amended, the plaintiffs have filed amended class actions. Let's see what the outcomes will be, what the district courts or the federal courts are going to decide on, and then see whether the administration is going to be happy or satisfied with it. They are likely going to appeal, whatever it is. If it goes against Trump, he's going to appeal. His admin will appeal. If it goes against the advocacy groups, they are also going to appeal. This matter will certainly end up again in the Supreme Court. So now, number 3, what has changed? Currently, practically nothing has changed, but theoretically, in 30 days from the date of the judgment, which was June 27th, the executive order restriction will go effect in 28 states, which did not sue to block the injunction. All right, so let me pull this up. Let's see here. All right, guys, hold pull this up here. Oh my goodness. There you go. I'm wanting to share my screen with YouTube, Facebook. I'm just hoping this could work. Let's see how. Guys, bear with me. I am trying to share my screen here to see if we can pull it up. Okay, it doesn't look like that is going to work. So let me share my screen from this Google Docs that I created. Okay. All right, so we have the state here that sued: Arizona, California, Colorado, Connecticut, Delaware, Hawaii, Illinois, Maine, Maryland, Massachusetts, Michigan, Minnesota, Nevada, New Jersey, New York, New Mexico, North Carolina, Oregon, Rhode Island, Vermont, Washington, and Wisconsin, obviously DC, and then the city and the county of San Francisco. All other states, the executive order is allowed to go into effect in 30 days if nothing changes, right? So many of the people, pregnant women are excessively worried what's going to happen. It all depends on, the state you're based in and the timing of your birth, of your child's birth or your due date. Okay, now let's go on. We'll get to that soon. The 4th question is this retroactive? Meaning, will it apply to people who've already been born, undocumented parents, who have already obtained US citizenship? The answer is no. Retroactive application of statutes, as I said last week, they are generally disfavored. the courts presume that statutes only apply prospectively to the future, not to the past, retroactively. Unless Congress states very clearly that a law should apply retroactively, the Supreme Court has also held that new statutes or new laws are presumed not to apply to events that occurred before the statutes were enacted. The presumption against statutory retroactivity is based on the fact that people should have an opportunity to know what the law is so that they can conform their conduct or habits or actions accordingly. Because if you have to give me fair warning. You said, okay, in 30 days, this is going to take effect. Then if I don't want what's going to take effect, then I can decide, okay, let me leave the US and go and give birth in another country. But you cannot create a new law and then expect it to apply to people who were not aware that this law was going to happen in the future. That would be unfair. So there is a presumption against retroactive application going back of statutes. Section 2 of the executive order that restricts birthright citizenship also said that the order should apply only to persons who are born within the US 30 days from the date of the order. Okay, so which is why there's always advance notice so that people can prepare themselves. Question number 6, DACA. If you have DACA, your husband or the father of the child is undocumented and you give birth, will baby get US citizenship? Currently, yes. But after July 7th, or perhaps before then, depending on what happens with the class action lawsuit, it depends on where baby is born. Okay, if the baby is born in one of the states that sued to block, then obviously they have an injunction until the litigation is done or the litigation is decided on. So in those states, it cannot take effect. So for example, if baby is born in District of Columbia or in Oregon where they sued, then even if you have DACA after July 27th, dad is undocumented, baby still gets US citizenship. If you have DACA, dad is undocumented, and you gave birth to baby, let's say July 30th, if the baby is born in the state of Virginia, then baby will not get US citizenship if nothing changes. As we've said, it's ongoing, litigation is ongoing. So maybe by next week, we could hear something from the court saying, okay, they blocked it based on the class action. It depends. Let's see how that goes. There's a lot of confusion about, I'm pregnant. Should I move to another state? Should I stay in my state? Some people are saying, well, move to a state which suits so that you are covered. Others are saying, just wait and see. You're just going to complicate delivery issues, obviously, because delivery is very stressful. You don't want to be now moving. But a lot of the states, for example, Virginia didn't sue, Maryland sued. So if you're in Maryland, if you're in Virginia, then it's not too hard to be able to, for example, go to Maryland to deliver. The point is that it's just going to result in a lot of chaos because now citizenship, citizenship for birthright, right? Jus soli, it's always based on the principle, where is the baby born? Jus soli, on what soil? And so if the baby is born on soil that favors birthright citizenship, then that's it. The baby will get the citizenship of the US, right? So if the baby is born in Massachusetts, where the executive order restricting birthright citizenship is currently blocked, then even after July 7th, baby will still get US citizenship. Even in another state which did not sue, will not get US citizenship. Just think about how chaotic the entire, very confusing. It's likely going to result in a lot of confusion because it's the hospitals, Department of State that are going to implement these things because hospitals will have to issue birth certificates. Perhaps there's going to be some portion that will have to list status of mom, immigration status of mom, or immigration status of dad. And then Department of State is also going to let us know how they're going to carry all this out. But it's likely going to result in a lot of confusion and chaos until things can settle down soon. Okay. All right, let's see here. Let's move on to our next topic for today, which is we're going to be talking about all the alligator Alcatraz and the things happening. Let's see here. All right, so we shared this on our social medias. There are, currently fines ongoing, civil fines for people who violate immigration law. So if you are given a removal order and you don't leave the United States as stipulated, or you tell a judge that you'll take voluntary departure after your removal proceedings and you don't leave, they calculate the number of days that you've been here where you have violated your immigration, the terms of your immigration status, and then they give you a financial penalty or money fine. So previously, what the administration was doing was that they would give you a 30-day notice, right? They'll send you something called a notice of intent to fine, an NOIF, and then they'll issue them and you would know that you are going to get fined. Now they're saying they're going to make it easier and more efficient to fine undocumented immigrants. DHS and guys, hold on. Yeah, DHS and the Department of Justice, Department of Homeland Security and Department of Justice, they came together to streamline the process. They're saying they are eliminating the 30-day notice period. If you are going to get fined, they're not going to give you a 30-day notice period. They're just going to send your fine to you by regular mail, no certified mail. And they have also shortened the process that applies if you want to contest your fine or say, no, I don't agree with this, or can you mitigate it or reduce the money? Because some people are getting $1.8 million fines, $2 million fines. Well, I believe $1.8 million fines is the maximum I've seen. $1.8 million fines, $800,000 fines, $900,000 fines. I mean, to get a $1.8 million fine, and if you don't pay, they're likely going to garnish your wages, start freezing the money maybe you're earning from as income, take if you have properties, they're likely to take your assets. And you guys, I mean, the administration is doing all it can to make life very impossible and difficult for undocumented immigrants. I mean, the height of it is obviously people who are trying to regularize their status going to court and then getting arrested. That it's at that point that you can see that they're doing everything they can, because some people are trying to do it the legal way, but still it's like there's no respite or rest for them at all. Okay, so now no 30-day period, and this took effect from June 27th. From June 27th, there's a new rule, no longer any notice, you get it. Now the fees are $100 to $500 for each unlawful entry or attempted entry. If you try to enter through the border, Texas, California, without a visa or without parole, US visa or parole to enter, you are going to get a fine, $500, $100 to $500 each attempt. If you make an attempt, you still get fined. I'm not sure how they're going to find people who attempt to enter and don't succeed in entering and then leave. Well, then we have $1,992 to about $9,970 if you fail to honor a voluntary departure, up to $998 per day if you fail to leave the US after a judge has ordered you removed, or after you've been ordered removed from the United States. Guys, make sure you're following our pages, AK Poku. If you haven't done so, please make sure you do so now before you forget. And if you can hear me, see me good, you're enjoying the live session, please drop USA, keep dropping USA in the chat box, okay? All right. So far, as of June 13, 2025, I believe DHS said they've issued nearly 10,000 fine notices. ICE has issued nearly 10,000 fine notices. And they're claiming that if you use the CBP Home app to leave, then you can get a forgiveness on the fines or penalties. Now let's talk about alligator Alcatraz. When I first saw it, I was in disbelief because, and I had a lot of people also tell me they thought this was AI or fake news, but it's actually real. It's just unimaginable. Some of the things happening, when you look at it, you think this is fake news, but it's actually happening. It's like the whole entire United States is a movie scene. That's what it feels like. It's like a movie scene that we are living in. Just so much happening, so many unbelievable things that are happening. So Alligator Alcatraz, you guys know that this has been built in Florida, a detention center to house undocumented immigrants or immigrants who are detained. Apparently, Alcatraz was a U.S. prison, a very tough U.S. prison in the 1930s. And it was very known for housing hardened criminals between 1934 to in the 1960s. And that Alcatraz Island is located in San Francisco, California. Apparently, Trump said he wanted it to come back. So there is a land, a very large, world's biggest airport in the middle of a place called Florida Everglades. And it was supposed to have, runways to handle jets and big airplanes. But after they built just one runway, the project was shut down in 1970 in Florida because there were a lot of environmental concerns. People were saying, no, this place is, don't use it for that. So the rest of the land was never developed. So the site is there empty and unused for decades in the middle of a swamp, like a wet area. It became bare because the full airport was never finished and it was just impractical for commercial use. So currently it's being, it was being used for pilot training. It was being used for, if you're a pilot, you want to know how to fly, that's where they would take you. They were doing pilot training. Until recently, Florida opened it on Tuesday, 1st July, into the Alligator Alcatraz Immigration Detention Center. And there are so many jokes about this because they're saying that it's a low-cost facility which is fortified by Mother Nature. The project has, the Alligator Alcatraz is surrounded by venomous pythons, alligators, and so once you are placed in there, you cannot escape. You cannot escape this Alcatraz. So, guys, what do you think about this? It's very shocking, and which is why DHS posted pictures of alligators. They've been posting pictures of alligators wearing ice hats on their social media pages coming soon. And I saw that they even created a social media page called Alligator Alcatraz, and it has alligators wearing hats and all these types of things there. Very unfortunate situation. This is a time where if you are undocumented, it's a really good time to make sure that you have reviewed your options. One of the things I've noticed about immigration law is that it's ever changing. So if you reviewed your options 5 years ago or 3 years ago, things could have changed. Things could have changed. You may be eligible for something. Not only could regulations or laws or circumstances have changed, your own factual circumstances could have also changed. So it's always good to check in to see, is there anything I could benefit from or anything I could do to regularize my status? Because it's just really getting serious with, they're just coming up with more and more and more to discourage people from being here, just to encourage self-deportation. We've said it in our previous past sessions. All of this is to encourage self-deportations and to ensure that people leave the US if they are undocumented, just so that they can have the numbers to say, oh yeah, we deported, or we've cleaned up the country of all undocumented immigrants. All right, now let's go back to denaturalization. Last week we reviewed it, and we shared this on our social media last week. I see that this week a lot of news outlets are now catching on to it, but this memo was published all the way in last month, June 11th. Okay, so denaturalization, and we also talked about it before. Once Trump was elected, and people said, "Oh, fear mongering," but you see it happening. Denaturalization. You are a naturalized U.S. citizen. They are going to make efforts to strip you of your U.S. citizenship from particular people. If you've lied, you lied to get the citizenship, you committed serious crimes, or you are considered a dangerous criminal. So they've created a list of priority cases, but as I said last week, it can go up. It can still go after others if they believe those other cases should also be pursued. When it comes to denaturalization, the federal government must meet a high burden of proof. If you're attempting to revoke somebody's citizenship or naturalization by civil proceedings or by criminal conviction for naturalization fraud, you got to make sure that you really could revoke it, because this is a right that has vested in you. The person has obtained U.S. citizenship, a U.S. passport, and so if somebody is going to take it away, they have to make sure that it really should be taken away. So for civil denaturalization, so there are two types, civil and criminal. For civil, government must show clear, convincing, and unequivocal evidence. It doesn't leave the issue in doubt. They just got to show that it's obviously not to the standard of beyond every reasonable doubt, but it must be clear, convincing, and unequivocal that you procured naturalization illegally, and or you concealed some material fact, or you willfully misrepresented a material fact during the naturalization process. I gave you an example. If you had children, you didn't state you had children, or you were previously married, and on your naturalization, you didn't say that, oh, you've been divorced before. That's a material misrepresentation that could affect you. For criminal conviction, the federal government must show proof beyond a reasonable doubt, for just as in all criminal cases, that you violated 18 U.S.C. section 1425 because you knowingly obtained or attempted to obtain naturalization through fraud for yourself or for another individual. Now, with the Department of Justice civil memo, it is for civil denaturalization proceedings. So that one is focusing on 8 U.S.C. section 1451A. We spoke about this last week. We'll go over that again. The United States attorneys for the respective districts, they would have to file an affidavit showing good cause to institute proceedings in any district court of the U.S. in the judicial district in which you are found. If you're a naturalized U.S. citizen, where you live, they will bring the suit in a district court where you live. So you live in Maryland, it will come in a district court where you reside. For the purpose of revoking and setting aside the order admitting such person to citizenship and canceling the certification of naturalization. So they will bring you to district court, they'll set aside the order that admits you to U.S. citizenship, and then they'll also cancel your certificate of naturalization on the grounds that your naturalization was illegally procured or procured by concealment of a material fact, number 2, or by 3, willful misrepresentation. Okay, and it will be cancelled as of the date of your order and certificates respectively. So if you got citizenship or citizenship through naturalization in 2008, it will go back to that date. All right. They gave a list of benefits of civil denaturalized. Here are the listed. I'm sorry, no. So these are the people they are going to be focused on. Number one, if you engage in war crimes, extrajudicial killings, or serious human rights abuse, I don't think there's a large number of people who have been involved in these type of things. If you are a criminal gang member or convicted of crimes and pose ongoing threat to US, that's the number two group of people. They are going to be removing these naturalized individuals. Again, I don't think this is such a large group of people. Number three, preventing convicted terrorists from returning to US soil, traveling internationally on US passport. So they have to pursue all these people. All right. Then, okay, so number three, organized crimes, those who are affiliated with gangs, cartels, transnational criminals. Number four, if you have undisclosed felonies. Five, undisclosed felonies. If you have, criminal convictions that are categorized as felonies. Rape, aggravated, things that have like murder. That's an aggravated felony. But there are felonies and there are aggravated felonies. You have any type of felony, any criminal activity that's classified as a felony. Again, when it comes to criminal law, each state has how it describes crimes. Some states will classify certain types of theft offenses that have firearms as felonies. Other states have different ways they categorize their crimes. So it just varies based on the state in which you are. Number five, violent or sexual crimes. This is not the time at all to get involved in violent or sexual crimes like rape, sexual assault, sexual battery, where you are raping a minor, including human trafficking and sex offenses. Number six, fraud against the US government, like PPP loan fraud or Medicare or Medicaid fraud. Seven, fraud against private parties. If you are scamming, targeting individuals and businesses, then you could be prioritized for denaturalization. Then citizenship obtained by corruption or lying. Then nine, you are referred by U.S. attorneys, cases connected to ongoing criminal cases, even if you're not listed above. Then 10, other significant cases. So long as the civil division believes it's important enough to pursue, they will pursue it. So these are just guidelines. They are not limits. They can still bring a denaturalization case, even if it doesn't fit one of these cases. The list is not ranked. No category is more important. DOJ has flexibility to assign cases based on expertise and resources. All right. So what you want to be aware of is that it's a good time to work with an immigration attorney to start pulling up your immigration records. Everybody and it's something I tell my clients all the time. Even if you are a naturalized US citizen, you should have copies of your own immigration records. You gotta have those copies. Now, when we pull it up, we're able to get it through soft copy PDF, and you can keep it in your archives. You get it if you have criminal records, even if the case has been expunged. Expungement doesn't have any effect on US immigration. Even if you've expunged your criminal records, it just means it's been sealed or sometimes just deleted, but you still have a record. For immigration purposes, expunged cases don't matter to them. So you got to make sure you have records and copies of all your immigration files, all your criminal cases. We can pull up your records from the US Embassy in all around the world, in your home country, from different federal agencies like the Customs and Border. What's happened when you're trying to enter the United States? We could also pull up your records from USCIS. You make sure that you have your records. It's very important, especially if you are concerned and you start proactively looking for solutions, building up your defense and your strategies before you are caught unawares. Guys, this week we've had reports about people who are detained in detention centers, and the government has been given a quota to make sure that people are getting deported by the numbers. And so they are coercing people to sign to voluntarily leave the United States. and these are things we started saying from January. We started saying from, December. Be careful if you happen to get into immigration detention. Be careful what you sign. These things are happening now. And so what we're telling you now, please don't wait until you see it happening live like a movie and you say, oh, I thought they were fear mongering, or I thought they were just saying something. This is a time to pull up all your records. Have it there. Make sure you have the records there. You have an attorney on call if there's anything, because they are not playing and things are happening quite fast. So it's a good time to do that. You need help pulling up your records, contact us. We'll help you pull up your records. And everybody is entitled under law called Freedom of Information Act to ask. We have I believe over 100 federal agencies in the US to ask the government, give me all the records you have on me. And the government has to comply within a set number of days. One of the things we see is that some people try to look on the internet and pull up their records, but sometimes if you don't know how to request the records well, you will request them and they will redact or withhold some of the information and give you some. So there's a way you have to request those records to get the maximum possible records that the government has on you. I like to say this a lot. Imagine entering a room, a dark room, and there are two men. You hear they have swords. They are about to pierce you. You also have a sword. You can only effectively utilize your sword after you turn on the light and you locate where they are. You see that, oh, he's here, he's here. Okay, let me go here first and go here next. Now, if you enter the room and you refuse to turn on the light, you will just be stabbing in the dark. And by the time you realize, somebody would have stabbed you from the back and you will fall down. So it's important to know what the government will be working with, right? Because if the government has to bring denaturalization proceedings against you, the records they are going to use are those records you can request. And here's what they did in 2018, the same Trump administration. In 2018, they set something up called Operation Janus. We also shared this last year when Trump was coming into power. We warned people they're going to be doing denaturalization. They did Operation Janus. They set up a whole department full of attorneys. And they started auditing millions of files, people who have obtained US citizenship, auditing with a fine-tooth comb, looking up things, checking data, interagency databases, looking for hits. What's going on here? Was there any misrepresentation, any fraud? Just double checking. And then they started putting people started receiving notices for denaturalization proceedings. So you don't want to wait until you don't have too much time to be able to defend yourself properly, or to, mount a proper defense for you. So it's a good time to make sure that you are proactive and not reactive. We can pull up your records, make sure you have all the relevant records ready for game time, just in case anything happens. It's easy because sometimes when you pull up the records, depending on the agency, so the agencies like CBP can take about 1 year, a year and a half. USCIS can take sometimes 4 months, 6 months, depending on the complexity of your records, whether you are requesting records in track 1 or track 2. How long ago, because these records, they keep them at NARA in their archive. So sometimes they have to go and pick them up. Sometimes too, maybe your records were taken there back in 2008. It might take time for them to retrieve their records. Other times you're in a queue. Sometimes you'll have 72,000 people ahead of you also trying to get their records. So all these things factor into how long it will take for you to receive your records back. I'm sorry, okay. All right, let's see. Okay, guys, let me take questions. We don't have too much time left, so I try to, run through some of the important things. Let's take questions. If you guys have questions, please drop them. And let me respond to them. Please keep dropping USA. If you heard me, you keep hearing me. If everything is clear, type USA. If you've understood, you've enjoyed the session, type USA. We still have some time. Please stick with us. We're about to take questions and answer them. If you have concerns, drop them and let's see how. Um, Don Zazchuk said Amaleka. Okay. Yes, America the Great. America the Great, America the Wonderful. It's like a movie scene. But seriously living a nightmare. I mean, as I said, if you can go to court trying to regularize the court where you're supposed to come to be heard and you are being arrested and detained, it's just mind blowing, seriously mind blowing. But we've told you there are strategies. We shared a video on how to avoid using the law, obviously, how to minimize, I would say, how to minimize ICE arrests in court. We've also shared videos on how to minimize ICE arrests at work or wherever you are. And people have found these videos really helpful. So please make sure to check out those videos. Nadia Muhammad Dwakas on Instagram says, "Hi, I need to file affidavits for my mom. I do not work, but my husband does the work. What form will I file? Please reply, thanks." So, yes, it's the form 864, but it's not just about the form 864, right? The affidavit of support form. It's not just about the form because you are the petitioner. So there's a way you have to handle the affidavit of support. As the petitioner, if you're not working, if you don't take care, you will file the form all right, but your mom will be denied based on inadmissibility, based on public charge rule. The Home Health Services, HHS, every year by March, they release something called the Federal Poverty Guidelines. And if you are filing for your petition for your mom or any family member, you want to be able to enter into a contract with the US government and say, you are petitioning or sponsoring your mom, or you are going to be financially responsible for her. You are making 125% above the federal poverty guideline for your household size. And so you will have to include a bunch of supporting documents, tax documents, tax returns, W-2s, employment verification. You have to make sure these things, your tax transcripts for some cases, and you are making the money. If you don't work, you didn't file taxes, there are things you have to check on the 864 and let them know you are not required to file taxes because you likely didn't meet the income threshold. And then we can look at whether you have a joint sponsor or a household wage member, what they also need to submit their own supporting documents. If you are even petitioning for yourself, or let's say you are a beneficiary. You are a beneficiary. Sometimes you can even use your social security quarters. If you've earned 40 quarters, about 10 years of work, then you may not need the 864 affidavit of support. You may need an exemption like the 864W. So it's the affidavit of support is one very key thing that people get wrong. So it's not just about what form, but you have to understand how it works. So call us, contact us, and let's see how we can help you. Okay. And one thing, and many lawyers say this, even if you feel like, oh, I don't have money to hire a lawyer, make sure you have a consultation, because a consultation can give you the clarity and guidance. And for someone like me, many of our clients say it a lot. They're like, attorney, you are so generous with your knowledge. I've been to 2 other lawyers and they didn't want me to file by themselves, so they didn't give me the information. But you've given me the information, you've sent me all this. And they always say that our legal consultations pay 10 times for themselves. Because even if you don't have the money to hire a lawyer, book a consultation. We can review your case and then we can give you better direction. Obviously, during a 30-minute call, we cannot teach you what we've learned in law school or immigration law, but at least it's a good starting point. Okay, so make sure you do that. All right, guys, keep dropping USA if you can hear me. If you have your question answered, also drop USA. Let's see that you heard us and it's been helpful to you. Okay. So let me start with the top one. I think the top one. Kobana Baka says, how soon can one remove conditions on a conditional green card if one is divorced? Okay. When it comes to removal of so let me start by saying again, there are two types of green cards. We have the 10-year green card and the 2-year conditional green card. You get a 10-year green card if you've been married for more than 2 years at the time of the approval of your case. You get a 2-year green card if you've been married for less than 2 years at the time of the approval of your green card case. If you are filing if you have a 2-year green card because you've been married for less than 2 years, the time your first green card got approved, you get a 2-year green card, right? Now, 90 days before the expiration of the 2-year green card, you have to file something called removal of conditions application. 90 days. If your spouse is joining you to file it. If you are divorced and your spouse says, I'm not helping you, go do it yourself, then there's no timeline. You can file it at any time, but you have to file it before you are placed in removal proceedings. If you are placed in removal proceedings, then that becomes a challenge, but you can do it at any time. So long as some conditions are met, you can file a removal of conditions based on something called a waiver, either based on annulment, based on divorce, based on battery or extreme cruelty, or based on hardship. One of these 4 grounds. Okay, Kobena. Bambitious Bambi on Facebook says, what's your fee to file an adjustment of status? Please contact us. Let's discuss with you what's going on. Some people need joint sponsors, some people don't. Some people, it depends. So we don't have a one size fits all. So contact us. Friends, thank you so much for joining. Yes, keep dropping USA in the chat box if you guys are continuing to enjoy and hear us real well. Imanola says, what advice would you give to someone who has been to the US on a B1, B2 visa, stayed legally 5 to 6 months, come back to Ghana, apply for F1 student visa, and was denied, but would like to try and apply for either B1, B2, and F1 again? It depends. I can't give any advice without knowing more. Generally, I would say if you come in for a B1, B2 visa, 5 months is a very long time. Some people do what we call visa runs. They will come with an I-94. The fact that, so as somebody will say, the fact that you can do it doesn't mean you should. Even the Bible has said it. The fact that it's expedient doesn't mean you should do it, right? You have the right to do all things, but it's not everything you should do. If you're coming into the US, the I-94 that the CBP will give you, they'll give you sometimes up to 6 months, usually up to 6 months. Some people get less, but you are given 6 months, but you want to, at this time especially, utilize it judiciously. If you're coming on vacation, it's just very shocking to the CBP officer how you can get a 5-month, 3-week vacation, because in the United States, that never happens. Nobody gets a 5-month, 3-week vacation. Tops, 2 weeks, 1 week. Some people have accrued, so maybe 3 weeks, but it's just very rare for anybody to get a 5-month, 3-week vacation. And so I'll tell you, the people that get flagged are the people that will come on visa runs. They will come 5 months, 3 weeks, 6 days. And then they'll go outside. And then they'll go outside back to their country for 1 month or 3 weeks or some time. And then come back in to reset their I-94 to get an additional 6 months. And if you do that, they get really mad because you're trying to utilize your B2 visa as a residency tool. You have a B2 visa. It just allows you to come in, visit, and go back to your country. So they don't like you staying for a long time. I don't know the basis of your, likely you got a 214B inability to demonstrate ties. It depends on your, what school did you get admission to, what program, what's your background, what do you do? So those are the things that could factor into whether you should try again or you shouldn't, or the timeline. So feel free to contact us and we can look at everything and give you the advice that will help you. Okay. All right, let me see if I can get something on TikTok. Yeah, TD Boy on TikTok says, can you get forgiveness if you overstay your visa and you're getting married to a US citizen? That's a great question. Montel Squire on Facebook Are you the same person who just asked the question on TikTok? Montel Squire. Yeah, okay. So there's something called bars to adjustment of status. If you want to adjust your status to get a green card, there are certain things that will be a bar, like that will block you from doing that. One of them is overstaying, something like overstaying your visa if you are not in lawful non-immigrant status. But we have some exceptions. Okay, so if you are married to a US citizen, you are the parent of a US citizen, or you're the minor child of a US citizen, or you are a victim of abuse under VAWA, for example, then you can be forgiven that overstay, and you are exempted from that thing that acts, the overstay that acts as a bar to adjustment. So it is possible you do get forgiveness generally for your overstay if you are married to a US citizen. So if you came in on a B2 visa, you've overstayed your B2 visa by 100 years, 50 years, 200 years. You're married to a US citizen, so long as you came into the US inspected and admitted with a visa or parole, then you can stay in the US and get your green card without leaving. So they generally forgive that overstay. All right, guys. Did you have any more questions or concerns? I think we have a lot more, but let me see here. Hansen Fixin says, I'm on F2 and have found a sponsor for EB3. Can I file with my F1 concurrently? What do you mean? You're on F2. Are you the spouse or the son of an F1 who's studying? Or I'm not sure I understand you, but yeah, EB3, if you found an employer, they can certainly apply for you. And immigration applications, you can have 4, 5, whatever number you want, immigration applications pending simultaneously. The law doesn't say you can only have one at a time. So if you're eligible for EB3, you can certainly file that. But please get in touch with us so we can review your case and see how we can help you. Hansen Fixin on TikTok, guys. Don't forget to like our page. Make sure you are following our page, not just seeing us and passing by. Follow our page and please interact with our pages across social media as we continue to bring you information as best as we can. Okay, engage with us. Make sure you follow our page, leave us comments, and share this feed with your loved ones. We've dropped a lot of nuggets in this video that can save somebody. You guys, you have no idea what's happening. There's a lot happening and our information is helping so many people. So share it because people are very afraid and cannot open up at this time to you. So do them a favor. All right, guys. So we didn't come live tomorrow. We will not be coming live tomorrow because tomorrow is a holiday in the United States. We're trying to come live on Fridays at 1 p.m. But we decided to do it Thursday today because tomorrow is July 4th of July. So we will not be seeing you tomorrow, but hopefully, and God willing, by next week, Friday, we will be back here live and I'll see you all. You can contact us if you need our help with any U.S. immigration matter on 802-780-0564. We represent immigrants in all 50 states throughout the United States, in all around the world, and in all U.S. immigration matters. Okay, so give us a call and we'll be very happy to work with you or assist you. Take care, guys. Have a wonderful 4th of July celebration. Please be safe. If you are undocumented, please, this is not the time to drink and drive or be, you are there, fireworks, and you are there with your beer bottle screaming and shouting and, doing anything funny, because if there's any issue, you could be picked up. Remember what we've shared here, 287G agreement. There's a lot of sheriffs and police departments acting as ICE officers. They are going to be on the alert tomorrow. So stay safe as you celebrate your 4th of July. And we've also said right here, the best place to avoid unreasonable searches and seizures is when you are in your home, according to the 4th Amendment. The home is the place where you are protected against unreasonable searches and seizures. So, just be guided accordingly and make sure that while you are, staying safe, you are also working with an attorney to figure out what your next steps could be. Because it means nothing if you keep playing hide and seek without taking active steps to figure out what you need to do. All right. So take care, guys. Thank you so much for joining. We appreciate each and every one of you. I'll see you soon in our live video next week. Take care. Bye. Bye, Instagram.